Hello, today I'm going to be talking to you about how to cancel your gym membership. I'll help you interpret the terms you signed up to and then cover the basic consumer law protecting you from being treated unfairly, including new things about the pandemic. If you've been treated unfairly, I'll explain the ways in which you might solve the problem. This means we'll discuss ways of communicating with your gym and how, if there's a problem, you can escalate your complaint further. When you signed up to your gym, you will have had to agree to certain terms and conditions. This formed your contract. The first thing you should do is read through those terms and conditions. One important thing is to find out whether your contract locks you into a minimum term of membership. You might have an annual membership, which means you paid an upfront amount in order to use the gym for a whole year, or you're committed to paying 12 installments. Or you might just have a monthly membership where, you guessed it, you pay a certain amount monthly to use the gym for that reason and can cancel at any time on a month's notice. Gyms such as Nuffield Health offer a monthly membership where you have to pay every month regardless of what type of membership you have, but in some cases you might get locked into your membership for a certain period of time, and even though you haven't paid a lump sum up front, you are still contractually bound to pay a certain amount each month for up to a year. Sometimes the name of your membership might not make things clear. David Lloyd, for example, has both a standard monthly and a standard yearly membership, but it also has a flexible membership. And in the standard monthly and standard yearly, you have to pay for the whole year. You just pay either a sum in one go or monthly installments. But the flexible membership, in this case, only runs for 3 months, and you have to give 1 month's notice as opposed to 3 months' notice in the other case. Depending on the type of membership you have, and it is important to check, there will be different ways to cancel. Generally, if you've paid a lump sum for a whole year, then you can cancel your gym membership by giving notice to your gym at least a month before that you don't want to pay for the following year. You might have to give as much as 3 months' notice, so read your contract carefully. If you're paying a monthly membership, it's normally as simple as cancelling your direct debit and giving notice to your gym, typically a month. It varies, which is why it's so important to check your contract, which will tell you what you need to do to cancel. If you do have to give notice, it could be in the form of a letter, an email, a phone call, or maybe just filling out an online form. But don't forget that if your membership is only meant to last for a year and it's going to expire soon, you shouldn't let it expire. It's more than likely that you have to give notice before your year end that you want to cancel your contract, otherwise it will probably auto-renew and your gym will continue taking money by direct debit. Your contract will also mention good reasons why the gym might let you out of your contract. These are usually things like having to move away from your local area for work, having financial issues that mean you can't pay for your membership, or illness. And in all these situations, you'll have to give proof that you can't carry on the membership anymore. If you're ill or injured, for example, you should provide a doctor's note. Gyms don't always accept your word, and the reason they don't always accept your word without some corroboration is because people have been known to lie to get out of fixed-term contracts. Now, the gym might offer to suspend your membership rather than cancel it straight away, but depending on the terms and conditions, you can opt to cancel. It's unlikely you'll be able to get a refund for the time you didn't use the gym, unless the gym isn't actually allowing you to access everything you're paying for, or unless the terms of the contract are unfair, which is something I'm going to cover now. While the rules of your gym might be slightly different to, say, your friend's gym, it's important to remember that government legislation is more important than any contract. The law beats the contract. All companies that provide services to consumers have to follow the law, and it's useful to know what rights you have in this area so you can avoid being treated unfairly if your gym won't let you cancel your contract or if they're abusing their power. The major piece of consumer law in England is the Consumer Rights Act 2015. Let's go through its main requirements. Section 49 of the Consumer Rights Act requires that every contract to supply a service is to be treated as including a term that the trader must perform the service with reasonable care and skill. Now, reasonable care and skill isn't expressly defined, but broadly the gym service should line up with industry practice, and the level of service should also reflect the price being paid. So if you're paying the minimum amount, if you're paying £12 a month for gym membership, good luck. You shouldn't expect to get absolutely everything the gym has to offer, or everything that a £75 a month gym membership would give you. Section 54 of the Consumer Rights Act gives you the power to enforce these provisions. And if you don't think the gym's providing you the service with reasonable care and skill, maybe they've closed certain aspects of the gym, maybe parts are often not working, maybe machinery is often out of order, maybe you don't have access to the personal trainers that you should do, then you have the right to ask for either repeat performance, doesn't really work with the gym, or a price reduction. A price reduction, as detailed by Section 56 of the Consumer Rights Act, might include a partial refund because the new price you have to pay is lower, or it might mean you don't have to pay anything at all, but that would be unusual. They have to give you the refund within 14 days and they can't charge a fee for this refund. So if they try to say an administrative fee of £9.95 per month is going to get slapped on, they're not allowed to do that. There's also a chance that a term or several terms of the contract are unfair. This is dealt with in Part 2 of the Consumer Rights Act 2015, and according to Section 62, an unfair term of a consumer contract is not binding on the consumer, that's you, so you don't have to stick to it. It's worth noting though that at the same time, if the unfair term works to your advantage, you can still rely on it. The gym can't say it's not enforceable if you're the one that wants to enforce it. The law sticks and sides with the consumer here. Now, there's a very full list of terms that could be unfair in Schedule 2 of the Consumer Rights Act, but in general, an unfair term is something that causes a significant imbalance in the parties' rights and obligations under the contract to the detriment of the consumer. And it's previously been ruled that minimum gym periods of over 12 months count as unfair terms, for example. If you think your contract contains an unfair term, you can report it to the Competition and Markets Authority, or maybe to another regulator, which will decide whether the term is unfair and will tell your gym what to do. We'll discuss how you should escalate your complaint shortly, but before that, I'll also mention another piece of consumer legislation, the Consumer Contract Regulations 2013. Now, this legislation only really applies to contracts which have been signed online. So if you signed your contract in person, and most gyms do require you to visit to sign the contract, or at least to visit the premises before signing the contract, none of this will apply. Now, the main takeaway from the Consumer Contract Regulations 2013 is you can cancel your gym membership without needing any reason if you've had the membership for less than 14 days. And according to Regulation 30 of the 2013 regulations, the cancellation period ends at the end of 14 days after the day on which the contract is entered into. And assuming to Regulation 36(1), your gym must not begin the supply of a service before the end of the cancellation period unless the consumer, that's you, has made an express request. So if you decided to start using the gym straight away, you should have asked your gym for early access. If you did ask for early access, but you've decided to cancel your membership within the 14 days, you have to pay the gym back for the time you used their facilities and the level of facilities used, but you can still cancel. The gym has to tell you about the cancellation period and has to give you a cancellation form, which has to be on paper unless you've agreed otherwise. And though most of these regulations don't apply to on-premises contracts, that's where you visited the gym before signing up, it's still specified by Regulation 9 that if you have an on-premises contract, your gym must tell you where you can access information such as the price you'll have to pay or how you can contact your gym. All your rights have to be communicated to you in a clear and comprehensible manner. As I mentioned before, if your gym hasn't done anything wrong and you don't have a good reason for leaving your gym other than the fact you've changed your mind, it's unlikely you'll be able to get your money back. And in that case, you need to fill out the cancellation form or call your gym to let them know you don't want to continue your membership. Cancel your direct debit, but you've got to tell the gym as well, just cancelling your direct debit may not be enough. You could end up being liable for the ongoing payments and could be sued for them a few years down the line. But once you've given notice to the gym, your membership is cancelled. Remember to give them a notice period of whatever the contract says. Typically, that'll be a month. If you do have to cancel your membership because of circumstances like debt, relocation, or injury, provide them with proof. Now, if you think your gym's at fault because your access to facilities has changed, or you have a problem with the service, for example, then you should go through the gym's formal complaints procedure. Now, that might mean emailing them to find out who to complain to or calling a helpline. If you think there's an unfair term in your contract, you can go to the Consumer Markets Authority. You can send an email to the address listed on the gym's website. If you want to contact the Consumer Markets Authority, go to the Consumer Market Authority website. The link is below and there are contact details there. Also, let your gym know what you're planning to do. Your gym probably doesn't want to risk its reputation by going to court against you or the Competition and Markets Authority and might decide to settle with you instead. Now, there is no specific ombudsman for gym memberships, so your complaint might end up being dealt with in the small claims court. Now, while gym membership contract disputes have gone to the High Court in the past, that's unusual because you're almost always dealing with amounts under £10,000. You would inevitably start your dispute in the small claims court. The Office of Fair Trading, which is now the Competition and Markets Authority, took a gym management company to court in 2011 over unfair terms in a gym contract and used evidence from people who'd been mistreated by the gym. The High Court found the gym company were in the wrong and that they'd taken advantage of the naivety of their gym members, who entered into the contract without realising how unreasonable the terms were. And its judgment drew heavily from the Consumer Protection from Unfair Trading Regulations 2008, which I haven't had time to cover today, but it's useful to look at if you think your gym might be engaging in unfair business practices. Now, we can only hope we've seen the last of coronavirus lockdowns and restrictions, but unfortunately, it looks like we're going to be feeling the impact of the pandemic for a while to come. It's more likely the use of your gym's been affected by COVID. The Competition and Markets Authority stated in 2020 that they would expect you to be offered a full refund if lockdown rules prevent you from receiving the service, which of course was the case for gyms. Now we are out of lockdown, this is less relevant, but you still might be entitled to compensation that your gym didn't tell you about if you kept paying for your gym membership even though you couldn't use it. The CMA has suggested in their guidance that you might have to ask your gym for a cancellation or a refund rather than the gym just offering it to you straight away. It's also possible that you received a partial service due to closures of things like swimming pools or group classes. You might have been offered online classes for the same price as an in-person class, and that's not the same quality, so you shouldn't normally expect to pay the same amount for both. And in that case, you could definitely ask for at least a price decrease or a refund in line with the Consumer Rights Act 2015, which I spoke about a little earlier. Thanks very much for watching. I hope this video has been useful for you and that you now know how to cancel your gym membership and what to do if you've been treated unfairly in your contract. These are some more videos on consumer rights. Do subscribe to my channel if you don't already do so, just here. I'm Barrister Daniel Barnett. This is a video you might like. Thank you for watching. Bye bye.